Hello friends, I would like to share recent judgment related to Eway bill under GST in Rajasthan High Court, wide writ petition number 5266 of 2021. The petitioners submitted that the goods and vehicle were lying detained with the respondent. Inspection and physical verification of the goods, including its weighment, has already been done. They have submitted that if they are detained for indefinite period, the condition of the stationary truck with weight of 38.12 metric ton on its tires and loss of business of the hopeless driver will not come back, and said that goods and vehicles are not required, at least for the purpose of inquiry. Petitioners have challenged order of detention and the very jurisdiction of respondent to proceed in the matter. When the respondent intercepted the goods and all the documents prescribed under the law, such as invoice, Eway bill and wage slip, were furnished. Yet he did not allow the petitioner to move. He firstly issued notice in MOV 2 and thereafter got extension to complete inspection from the competent authority, simply with a view to conduct inquiry relating to alleged wrongful availment of input tax credit. Here this input tax credit means the ITC of the document. Petitioners argued that such inquiry, if at all is necessary, the same is permissible to be done by regular assessing officer only, and not by the anti-evasion officer or any check post in charge or flying squad, as done in this case. Here the input tax credit notice and all done by anti-evasion officer only in this case. Court's attention was invited by the council towards the circular dated 10/4/2018 issued by the Central Board of Indirect Taxes and Customs. He has submitted that an officer empowered to intercept and inspect a conveyance is only required to verify prescribed documents, and where prima facie no discrepancies are found, is required to allow the goods to move further. Having heard learned counsel for the parties, court was of prima facie view that the provisions of sections 67, 68 and 129 of the Act of 2017 are required to be interpreted. Here the section 67, 68, 129 of the Act refers to the CGST Act, that is Central Goods and Services Act. And the court also said that the circular dated 13/4/2018 issued by the CBAC, that is Central Board of Indirect Taxes and Customs, lays down guidelines for inspection and release of the goods in transit, but the same has not been adopted by the respondent in this case here. Court found that upon perusal of detention memo and physical verification report, it is an admitted case of respondent that all the documents prescribed under law were available and goods including its weight was found in order. Court also found that even genuineness of the goods in transit is not in dispute, in as much as documents, Eway bill and other documents in relation to transit of 34.12 tons of MS scrap in quantity and the nature of goods on physical examination was found to be in accord. Court said as a preliminary opinion that the scope of the inquiry under 68 of the Act of 2017, that is CGST Act, by anti-evasion officer or check post officer or flying squad ends once the goods in question are in conformity with the documents of transit. So the court, that means in the opinion of the court, when everything is correct, the flying squad has to end this investigation there itself. That was it meant. And the respondent cannot kickstart an inquiry relating to the genuineness of purchase and the corresponding input tax credits, that is ITC, which essentially relates to purchase of goods only. So as we all know that the ITC is relating to the purchase of goods only. It is taking place after receipt of goods and at the end of receiver only. And the court also said no satisfactory reason has surfaced justifying the inquiry being conducted by the respondent. And a complete report of the Judicial Assessing Authority, as mentioned, is also not on record. That apart, final decision of the case will require a rather thorough examination of facts and law and in-depth deliberation. Having regard to the fact that goods and vehicle are lying stationed or otherwise detained with the respondent, and inspection and physical verification of the goods, including surveyment, has already been done, goods and vehicle are not required, at least for the purpose of inquiry. If they are detained for indefinite period, the condition of the stationary truck with weight of 38.12 metric ton on its tires and the loss of business of the driver will be lost. So then the court, considering what has been discussed above till now, and in the interest of justice, respondent has directed, and in the interest of justice, he has directed the respondent to release the goods and vehicle in question. And in case of that is by giving one more if clause here, it has said that the petitioner has to furnish 2 solvent sureties to the tune of 15 lakhs executed by dealers registered in the state of Rajasthan. And then again it has also put one condition saying that respondent shall not insist upon furnishing of bank guarantee or cash security. Then the petitioner was asked to file an undertaking before the court that in the event of dismissal of the writ petition, upon final determination of liability, if any that arises when the final course of action is taken place, the amount would be paid. That is, the undertaking will reflect these things, subject to the rights of availing appropriate remedies. So in this video, I think we are useful to you, and this relatively fair idea about Eway bill related issues we used to have in our mind when the Eway bill and all common for all businesses. I request you to like, share and subscribe this video. Thanks for watching this video, and bye for now. Thank you.